Imagine waiting 5 years for your dream block of land. You sign the contract, pay your deposit, and plan your entire life around it. Then one day, you open your mailbox and find a single letter. Your contract has been cancelled. This isn't a hypothetical nightmare. This just happened to more than 100 home buyers in South Australia. They got their deposits back, but they lost 5 years of waiting and the opportunity to buy that land at the original price. The immediate reaction of most people is, how is this even legal? A signed contract is a signed contract, right? Well, not always, especially when you buy something that doesn't exist yet. Because when you buy off the plan or house and land package, you aren't just buying land. You're buying into a long, uncertain process where planning rules, infrastructure requirements, construction costs, and unexpected issues can change outcome. Today, let's look at the hidden clause behind this Adelaide case and the key risks every buyer needs to understand before signing a property contract. Whether this developer acted out of genuine necessity or financial calculation isn't for me to say. But here's what this case highlights. While a contract gives one party a way out while locking the other party in for 5 years, buyers need to understand where the potential problems and imbalance may exist. To understand how this really works, let's look at what actually happened on the ground. According to public reports, the developer said the cancellations were due to changes in surrounding road planning. They argued that the change will significantly affect the project and the lots could no longer be delivered as originally planned. However, this explanation has been strongly challenged by buyers, the local council, and government representatives. The final outcome of this dispute is still being debated. Cases like this highlight the risks of off-the-plan purchases. These projects can take years to complete, and during that time, planning decisions, market conditions, and land values can change a lot. But buyers are often locked into contracts based on assumptions that existed years earlier. This is the part many off-the-plan buyers underestimate. They agree to buy price and conditions based on today's information, but the project itself may not be completed for several years. And this is where one of the most important contract terms comes in, the sunset clause. Before we go further, just a quick note, this is general information, no legal advice. Many buyers have heard of this term, but they usually see it as a protection if a project is delayed for too long. What many people don't realize is that this clause can work both ways. Originally, it was designed to protect buyers from being stuck in projects that could not be completed. However, buyers also need to understand that, depending on the contract terms, a sunset clause may give developers a way to terminate the agreement under certain conditions. The sunset clause is just one example of the risks created by the gap between signing a contract and completing a project. The same uncertainty exists with house and land package. Many buyers assume the process is simple: buy the land, build a house, and move in. But in reality, there are many moving parts between signing the contract and receiving the keys. Having spent years in Melbourne's property development sector, I've seen construction costs increase dramatically between contracts being signed and project completion. In recent years, we have seen how quickly construction costs can change. Material prices and labor costs rose sharply, and many builders who had quoted projects based on earlier cost estimates suddenly face much higher expenses. Buyers naturally asked, if the contract was already signed, why should I pay more? And that is a very reasonable question. However, for buyers, the key question is not only why costs changed, but also how those changes are handled in the contract they signed. And this brings us back to the sunset clause. If a buyer faces a delayed project or a contract issue, what options do they usually have? Usually, there are a few options. The first option is to negotiate and continue. If unexpected delays or cost increases put the project at risk, both sides might try to agree on revised financial terms or updated timelines to keep the project moving. The key question for the buyer is whether the updated terms still make sense and if the developer can actually deliver. The second option is to walk away. Sometimes receiving your deposit back and moving on may be the most practical option depending on the situations. This can happen if the new terms no longer make sense or if the uncertainty has become too high. The difficult part is that buyers may have already spent years waiting for the project to complete. After investing so much time, it can be very hard to walk away, even when things have changed. The third option is to challenging the decision. For some buyers, this may be the path they choose if they believe their rights have not been protected. However, legal processes can take time, and buyers need to understand the costs, timelines, and uncertainty involved before making that decision. So if you are considering buying a house and land package or an off-the-plan property in Australia, what should you look at before signing? The first thing is the project timeline. Ask yourself, how far has this project actually progressed? Has the land already reached a stage where titles can be issued? Are important approvals already completed? The longer the timeline, the more uncertainty you are taking on. The second thing is the contract itself. Many buyers focus mainly on the price, but the details inside the contract can be just as important. Paying particular attention to the sunset clause, settlement timeframes, conditions related to approvals, and any clauses that allow changes in unexpected situations. The third thing is understanding your own risk tolerance. A new estate can offer many advantages: a brand new home, modern infrastructure, and potential future growth, but it also comes with a higher level of uncertainty. An established property may offer less future upside, but you have a clearer picture of what you are buying. The recent Adelaide case is a reminder that a property contract is not just about the price or the property itself. It's also about understanding the process behind it and the uncertainties that can come up along the way. For buyers, understanding these potential issues before signing can help them make more informed decisions about what they're committing to. If this video helped you understand more about the hidden risks behind Australian property development, please like and subscribe to April Talks Aussie. I will continue sharing more insights into Australian property market, the stories behind the numbers, and the things buyers should know before making important property decisions.